Hi everyone, welcome to the third segment, or as you might see it, the second lecture in this week's series, where I will be talking about the legal aspects of non-normative sexualities in the United States. And this is a topic that sounds, I think, kind of dry on its surface, but it's not really, because when you think about it, the legal status of folks reflects really our notions of who counts in a society, what are basic human rights, and who deserves to have them. So these are questions of cultural interest as well. It's absolutely not just a matter of arcane legal theory by any means. As I mentioned in the prior lectures, I mentioned the case of Lawrence versus Texas in 2003, which finally struck down state laws that held quote-unquote sodomy to be illegal. This came on the heels of a 1986 Supreme Court decision, Bowers versus Hardwick, which had upheld actually a Georgia state law banning sodomy. So the court really had to reverse its previous decision, and it did so in 1993 or in 2003 with the Lawrence versus Texas case, a case where ironically not all of the protagonists were even necessarily gay, but the case started when some guys were drinking, there arose an altercation, the police were called in, and on the walls were some naked homoerotic art, which then spurred the cops to make an arrest. There appears to have been some kind of sexual contact going on, but not necessarily between the two fellows who were charged with it. The case was then seized upon by advocates who were looking for a test case, and they took it all the way to the Supreme Court, where in 2003 the court ruled that sodomy laws were unconstitutional. The basic rationale that the court leaned upon in that decision, which was written by Anthony Kennedy, that's significant because he's often the swing vote on the court, was the concept of privacy rights, which is an idea that goes back to the 1960s and early 70s, and the body of legislation that made abortion and birth control legal. We'll get to those topics later in the term. Significantly also, in a dissenting opinion, Sandra Day O'Connor, who has since left the court, who has since retired, concurred with the overall opinion, but wanted to place it on a different basis, that of equal protection under the 14th Amendment. I will loop back around to that justification at the end because it is important in a case that's pending right now at the court. Okay, so 2003, homosexual acts were finally deemed no longer illegal. But of course, there are still many legal barriers to complete equality. For instance, there's been a Non-Discrimination Act pending in Congress for years and years, and they just have not passed the thing. It would add sexual orientation to the list of categories that cannot be discriminated against in the workplace. One of the contentious issues there has been whether the rights of transgender and transsexual people ought to be equally protected as well. Another legal barrier until very recently was don't ask, don't tell, which was a policy in the U.S. military that allowed gays to serve as long as they kept themselves thoroughly in the closet. And this was basically a sort of lazy compromise reached by the Clinton administration, where Clinton sort of originally came out and said, well, yeah, we can have gays serving, and then there was a firestorm in the early 90s. The American public was not ready to admit that there might be gay soldiers. There were worries about morale. Oh my God, what happens if you're out there in the trenches and the other guy might be into you? All of this kind of, paranoid thinking, or at least to our eyes today, it appears kind of paranoid. At the time, it appeared to be quite mainstream. And so Clinton, in his usual triangulating way, struck a compromise which basically allowed gays to serve, and the price for that was that they had to essentially deny every aspect of their private lives. This don't ask, don't tell policy was finally overturned just a year ago in 2011 when the Obama administration decided it was time to stop fighting it. Now, the most famous area, the area you are probably most familiar with when it comes to working towards full legal rights for gay and lesbian Americans, is the issue of marriage equality. Sometimes people call it gay marriage, and I'm going to avoid that term because it could also include bisexuals. Basically, it just means that everybody ought to have an equal right to get married. This is a principle that goes back to that court case I mentioned earlier this quarter when we talked about anti-miscegenation laws, Loving versus Virginia, where the Supreme Court held that barring marriage on racial grounds essentially violated a basic human right. And interestingly, Mildred Loving herself, who was one of the plaintiffs in that case, half of the couple who had married, came out recently, a few years ago before her death, and supported publicly marriage equality on the grounds that the issues were essentially the same as they had been in her case as well. In 1996, the federal government passed the Defense of Marriage Act, also known as the DOMA. At the time, Bill Clinton was president, and this bill enjoyed bipartisan support. Today, I don't think you could get the Democrats on board with passing such a piece of legislation, but at the time, it was a no-brainer that neither party was willing to come out in favor of marriage equality. That has changed insofar as, of course, President Obama came out in favor of it last spring, claiming that his position had undergone evolution. And this summer, the Democratic National Committee's platform specifically added support for full marriage equality. The DOMA at the federal level meant that states did not have to recognize same-sex marriages performed elsewhere in the United States. Subsequent to that, a great many states have passed either legislation or constitutional amendments that restrict the rights of same-sex couples to marry. In a somewhat later development, a number of states have begun to explicitly allow same-sex marriage to occur. So if you look at this map, which comes from Wikipedia, you can see what amounts to a patchwork, a crazy quilt of state-level Defense of Marriage Acts, or DOMAs. So again, there's a federal DOMA, and then many states have their own versions thereof. To take Ohio as an example, we're shown in dark maroon, which means that not only do we have a constitutional amendment prohibiting same-sex marriage, we also have an amendment that prohibits civil unions in certain forms. Contrast that with a state like Tennessee, where only same-sex marriage per se is banned. The light red-colored or pinkish, sort of salmon-colored states are states in which only a statute prohibits same-sex marriage. And this matters because if you are going to go change the law, a constitutional amendment very typically requires more votes, usually some kind of a supermajority, either in the legislature or in the popular vote if it goes to a ballot, or both. So in Ohio, it's going to be harder to overturn than in Wyoming, for instance. The dark blue states are all places where full-fledged same-sex marriage has been adopted, and they are, for the most part, as you might expect, clustered in the northeast of the United States, where they're just generally more liberal states, where support for civil unions was initially strong, as in Vermont, and then starting with Massachusetts, either the courts or the populace came on board. So Massachusetts, for instance, the first state to allow full-fledged marriage, passed that, or rather implemented that through an act of the state Supreme Court, but by now popular opinion has caught up with it. This contrasts with Iowa, where you've got, again, an opinion by the state constitutional court, the state Supreme Court, saying that it would be unconstitutional in that state to bar same-sex couples from marrying. But in Iowa, this has been hotly contested with efforts to replace judges through the electoral process who have supported same-sex marriage. Now, the map is a little bit out of date. Since then, both Washington and Maryland have voted in their legislatures for full-fledged marriage equality. New Jersey voted for it as well, and the governor vetoed it. At this point, eyes are on Maine, where there will be a ballot initiative this fall in 2012 to determine for the second time whether same-sex marriage is allowed. And I want to make special note of California, which at one point, for a narrow window of several months in 2008, had same-sex marriage after the state Supreme Court decreed that it was constitutional and it must be allowed. That was ended in the fall of 2008 with Proposition 18, which essentially rolled back that court decision by a popular vote. It won with a simple majority, a fairly tight majority, and it's questionable whether it would triumph again 4 years later in a time where a majority of Americans now express support for marriage equality. So in the aftermath of Prop 8 out in California, a lawsuit was filed by two couples called Perry versus Schwarzenegger. Perry's the name of one of the women in the two couples. Arnold Schwarzenegger was, of course, governor at the time, and so he's named in the suit, even though, ironically, he supports marriage equality personally. That is now winding its way through the courts and has made it to the sort of district appellate level. There is a chance that that will end up at the Supreme Court, and if it does, then it would be a test case for marriage equality more broadly, unless for some reason the Supreme Court decided to state that it only was deciding on this particular narrow law in California. The appeal has been lodged on the basis of the Equal Protection Clause of the 14th Amendment, which I mentioned earlier, which simply states that everyone is to be treated equally. This is one of the amendments that was made after the Civil War, and historically it has been interpreted by the courts to mean that race and religion are particularly protected categories, also known as suspect classes, which doesn't mean that the people are suspicious. It just means that the courts should be on the alert or should be suspicious that discrimination could be afoot. And so by making this argument, the lawyers in the case are trying to stretch the definition of the equal or the scope of the Equal Protection Act clause, further than it has been in the past. And as such, this is seen as a relatively risky move by a lot of longtime advocates of gay rights, simply because we don't know if this court will vote in favor of marriage equality if it really comes to that fundamental question. Lurking behind this whole debate is sort of a broader philosophical question of what kinds of things a society can and should regulate. Going back to one of the philosophers of the 19th century, John Stuart Mill of England, Mill made the point that a society that cares about liberty should only regulate or prohibit those acts that are shown to cause harm. And a number of philosophers have more recently argued that since marriage equality harms no one, that there is no reason to restrict liberty on that basis. Philosopher Martha Nussbaum has taken this a bit further with her analysis of what she calls the politics of disgust versus the politics of empathy. She says that historically and today in some circles where opposition to marriage equality is still strong, that there is a politics of disgust that basically frames homosexual acts and therefore homosexual individuals as disgusting and therefore a threat somehow to the common good and therefore liable to be regulated under the harm principle. Now, she counterposes against that what she calls a politics of empathy, by which she means through empathizing with people, through seeing them as fellow human beings deserving of the same kinds of protections, support is building for marriage equality. And indeed, again, the polls show that very strongly, with the majority of Americans now supporting it. And basically, Nussbaum says, look, what happens here is that people take an imaginative leap. They think that could be me, but for the grace of whatever accident of birth, and therefore are open to the idea of extending marriage rights to all.